Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Be it a cremation ground or burial site, families of infected or suspected COVID-19 patients are having a harrowing time performing the last rites of their loved ones. But this is where courts have stepped in over the past 2 months, declaring the right to have a decent burial as a fundamental right. And this is what we began KYC or Know Your Constitution this week with.
Last month, the Madras High Court registered a suo motu PIL after a mob of local people obstructed the burial of a doctor who died from COVID-19. The bench referred to Supreme Court judgments which ruled that the right to life under Article 21 cannot be restricted to a mere animal existence and means more than just physical survival. It then observed that Article 21 therefore includes the right to have a decent burial. This was followed by a Bombay High Court judgment last week after a few Bandra residents approached the court against usage of burial grounds around their homes to dispose of bodies of those who passed away due to COVID-19. Rejecting the petitions, the court emphasized on the right to a decent burial as a part of right to life. It found no reason to deprive the dead of their last right, which said was the right to a decent burial according to their religion.
Next, we told you about the right to a fair trial, which has been recognized as an integral part of Article 21 of the Constitution. The Supreme Court, in a variety of judgments, has held that the right to fair trial is an important part of the right to life and liberty. In a landmark 1979 case, which also was the first public interest litigation in India, the Supreme Court held that speedy trial is also an integral part of the right to life under Article 21. Several judgments have since declared various other aspects as principles of a fair trial. These include having an impartial judge, getting free legal services, and the benefit of the belief that you are innocent until proven guilty. A 9-judge bench in 1966 had also emphasized the importance of open courts where people can enter and watch the trial. The court had said that a public trial in open court is essential for the healthy, objective, and fair administration of justice. In fact, this is the case often cited as a criticism for the ongoing video conference proceedings taking place in the Supreme Court due to the lockdown and COVID-19 threat. This is because these proceedings can only be viewed by the lawyers and their clients and not the public in general. When asked about the most important constitutional provision, Dr BR Ambedkar had called Article 32 the heart and soul of the Constitution. And that's what we told you about next on KYC.
Under Article 32, any individual can approach the Supreme Court if they feel that their fundamental rights have been violated or need to be enforced. It also empowers the Supreme Court to entertain writ petitions, including habeas corpus petitions. Importantly, Article 32 itself is a fundamental right. And the Supreme Court, as early as 1986, held that its powers under Article 32 form a part of the basic structure of the Constitution. Article 32, the provision, also gives extensive powers to the Supreme Court. For instance, in addition to awarding compensation for illegal detention in a petition under Article 32, the Supreme Court also issued detailed mandatory directions for all law enforcement officials to comply with when they arrest or detain any person. It was also Article 32 that the Supreme Court had cited to issue the landmark Vishakha Guidelines on Sexual Harassment at Workplace in 1997.
We've often heard about several sorts of public interest litigations being filed and heard throughout the country. So next in KYC, we told you what PILs are, how they're different from normal petitions, and how they help in enforcement of fundamental rights.
Traditionally, people can approach the Supreme Court under Article 32 and High Courts under Article 226 against violation of their fundamental rights. However, there are times when, because of poverty or lack of awareness, people might not be able to approach the courts themselves. This is what the Supreme Court recognized when Justices VR Krishna Iyer and PN Bhagwati began laying down the framework for PILs in the 1970s and 80s. They essentially allowed people who weren't themselves deprived of their rights to approach the court under Articles 32 and 226 on behalf of the aggrieved. Justice Krishna Iyer sowed the seeds for this relaxation through a case in 1976. This was followed by a landmark 1979 judgment on undertrials in Bihar by Justice Bhagwati. The case was initiated on a habeas corpus petition filed by senior advocate Kapila Hingorani on behalf of the undertrials in the Supreme Court. Hingorani came to be known as the mother of PILs. Since then, letters and even postcards have been accepted as PILs by the Supreme Court. Courts have entertained PILs in several issues, including police brutalities, working conditions of laborers, transfer of judges, and live streaming of cases. However, this has also been criticized because frivolous PILs on issues that don't involve any public interest continue to clog the courts.
This is Apoorva Mandhani for ThePrint. Do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.